Ready? Start. Challenge in this appeal is to the order passed by a learned single judge of Jharkhand High Court, setting aside the order of acquittal recorded by the trial court in favor of the present appellants by allowing the revision filed by respondent number 1 Rajesh bracket herein after referred to as the informant bracket close full stop. Learned counsel for the appellants submitted that the approach of the High Court is clearly erroneous. Full stop. No reasons have been indicated to show that there was any infirmity in the trial court's judgment. Full stop. In fact, according to him, the trial court's judgment was a very detailed one and ample reasons were indicated. Full stop. The High Court, without even pointing out as to what infirmity existed in a mechanical manner, directed the matter to be reheard. Full stop. Abrupt conclusion was arrived at that the trial court had not appreciated the evidence on record in its right perspective and by misappropriation of evidence directed acquittal. Full stop. It is submitted that it has not been indicated as to how the evidence has not been appreciated in the right perspective and oblique or how there was misappropriation of evidence. Full stop. It is pointed out that the revision was not maintainable at the instance of the complainant. Full stop. The exercise of revisional jurisdiction has to be within limited parameters. Full stop. Unless there are glaring defects in the procedure or manifest errors of law leading to great miscarriage of justice, there is no scope for interference. Full stop. It is pointed out that the alleged occurrence took place on 2011-1994 and a complaint was filed after about 13 months, that is on 11/12/1995. Full stop para. Learned counsel for respondent number 1 submitted that though the High Court has not referred to the evidence in detail, the conclusions of the trial court are sufficient to show that the appellants were guilty of alleged offense. Full stop. The impugned order of the High Court reads as follows. Heard. This revision has been filed by the informant against the impugned judgment by which the accused persons were acquitted from the charges under sections 364, 366A, 368 and 120B of the Indian Penal Code. Full stop para. It appears from the impugned judgment that though the trial court held that the minor girl Sarita Kumari was kidnapped from the lawful guardianship of her father, but by discarding the evidence of PW's full stop on the ground that they are hearsay and further rejecting the evidence of the prosecutrix Sarita Kumari on the ground that the same was contradictory to her statement made under section 164 CRPC, acquitted the accused persons, holding that the prosecution failed to produce any reliable evidence. Full stop para. In my view, the trial court has not appreciated the evidence on record in its right perspective and by misappreciation of evidence has acquitted the accused persons. Full stop para. Accordingly, without giving any specific finding on the evidence on record, the matter is being remitted to the trial court by setting aside the impugned order with a direction to the trial court to consider the materials and evidence on record, afresh in its right perspective and pass a fresh judgment in accordance with law. After hearing the parties on the basis of the materials already on record within a period of 8 weeks from the date of a copy of this order full stop